All right, I want to start with a hypothetical here, and it might seem a little far-fetched, but I promise this is the exact principle that we're going to be talking throughout this podcast. If you build a highway, okay, and a criminal uses it after robbing a bank, should you go to prison for a conspiracy crime? That answer is obviously no. The answer should be no, or else people will stop building highways and apply that to any other tool, and people will stop building tools. What's happening to software developers could begin a slippery slope that extends well beyond software to any builder of tools. That's why I felt I had to make this podcast. This is for anyone who wants to understand what's happening to software developers and how that could be a slippery slope that affects any builder of tools and the world that we live in today. If you want to understand money transmission law and developer liability, I promise that when you finish this zero jargon podcast, you'll understand what's happening better than anyone you know. Yes, it is crypto, it is software development, but I explain everything in a way that you can understand even if you have no background. So for those of you who are new, welcome to Law of Code. This is the podcast covering the legal layer of emerging technology. I'm Jacob Robinson, and my goal is to help people understand the rules that shape our society. I want to build basically the Huberman Lab version of a legal podcast. It should be the best legal podcast you've ever heard. And if it's not, let me know why it's not, and I'll improve. Now, this is episode 200 of Law of Code. I've been doing this for almost 6 years now. I wanted to signal a new approach to the podcast. Each episode is an audio guide on a particular legal topic. And to prepare, I spend about 50 non-billable hours, no exaggeration, reading legal complaints, court decisions, speeches, press releases from the DOJ, guidance from FinCEN, expert opinions filed in the Netherlands. Then I spoke to the leading experts in the field. I recorded and edited those interviews myself to produce this podcast and included them all here. It was pretty exhaustive. I really loved it, though. If you want more content like this, please help me out by sharing this podcast with anyone who might be interested, sharing on socials, subscribing, and leaving a review on whatever podcast app you're listening. I also have a free newsletter that's linked in the show notes below. It's not another, long, boring legal email. It's just 5 bullets once a week. It's the shortest legal newsletter in the world. You can find it at lawofcode.fm. So instead of .com.fm, because it's a podcast. Now, for lawyers in Ontario, Canada, this podcast is eligible for continuing legal education hours. For American lawyers, I'm working on getting this accredited in every state. So now joining me throughout this episode are Coin Center's Peter Van Valkenburgh. He's the executive director there, as well as the DeFi Education Fund's chief executive officer, Amanda Tuminelli, and Brian Klein. He's a partner at Cooley and the lawyer for Roman Storm, someone who we're going to be talking about throughout this episode. Now, I just want to be clear before we start. This is not a podcast about software developers. It's not a podcast about money transmission. Yes, that's what you're going to learn about, but this is about freedom, and this is about the future of financial innovation in the world, because other countries follow what the US does and will do here, and some countries already have. Now, as you'll see in this podcast, I've intermixed parts of the interviews that I've done when they fit, when we want to bring in a legal expert or some sort of expert to talk to you about the situation. I'll start with Peter Van Valkenburgh to explain really what's at stake here.
This is not actually about crypto. This is just about our American system, which believes in the rule of law and believes that if you want the benefit of the rule of law, you need to uphold the rule of law, even when it's your enemy that you're protecting. You believe in the law. I believe in the law. That's why we need to clarify the law. We're not trying to take power out of your hands as a prosecutor. We're trying to sharpen that element of power that you have so it doesn't get misapplied, so that people still maintain faith in the legitimacy of the law, and so that Americans who want to build these tools don't end up on the wrong side of a prosecution when they did nothing wrong, and so that these tools continue to be built in America so that you don't have to launch your investigation to, Southeast Asia in order to bring someone in for money laundering with no American technologists as peers and facilitators in those investigations.
All right, so now that you know what's at stake, a quick legal disclaimer, and then we'll get into the podcast.
Anything mentioned in this episode by Jacob Robinson or his guests is not legal advice or investment advice. All opinions are Jacob's and his guests alone. Nothing discussed today should be relied upon for legal or investment decisions. This show is solely for information and entertainment purposes only. Jacob and his guests are not your lawyers, nor are they investment advisors. Please work directly with a lawyer or investment professional.
All right, let's go. First, what software developers are we talking about? Well, all of them, actually. Taken to the extreme, that position that publishing code, i.e. building something that someone else uses, implicates you for someone else's crimes is a dangerous free speech issue and a dangerous precedent for all of us. Peter van Valkenburgh puts it really well here.
The thought that mere knowledge of a hypothetical bad use of your open source code in the future is enough to prove criminal conspiracy, whether it's for money laundering or for sanctions violation or for unlicensed money transmission, which, again, we'll talk about this later, is the charge that I take the most umbrage towards. That standard of criminal culpability would simply grind all software development to a halt in the United States. No one would want to publish anything that is of particularly good use because, of course, the best tools are going to be used by bad people. In fact, bad people are more likely to use really good tools than good people because they don't have the backstop of a contract and legal system behind them when things break. So they need their tools not to break. They need their tools to work really well. And so if you set up a legal standard that says developers of software, if they have even an inkling that their tools will be used in the future for bad things, then they can be ultimately culpable when those tools are used for bad things. You're basically giving the worst people in the world, the criminals and the terrorists, a veto right on good people developing good technologies for ordinary uses.
So, yeah, this is really, really important stuff. Now, to make it a bit more tangible, the specific stories and cases we're covering here are about developers of non-custodial interfaces and related smart contracts. Now, as I said, this is not a jargon-filled crypto podcast, so don't worry. All you need to know is that these developers build and publish tools. They never control or hold the underlying assets that move, much like whichever company provides internet to your house never touches any assets that you might move via the internet. Now, the distinction between custodial and non-custodial is self-evident. At a custodial service, you hand over your assets to someone who holds them, who custodies them for you. Coinbase is custodial, banks are custodial. Think of it like an Uber driver for your assets. Someone is taking them to the destination. Now, non-custodial software is where you use software to move your own assets, much like how you use Google Maps to drive your own car. Like Google Maps, developers of non-custodial software simply build tools that you or I might use. Tornado Cash is a non-custodial tool, and MetaMask is a non-custodial tool. Now, that distinction is key. So if we take that hypothetical a step further, let's say you just robbed a bank and you need a getaway driver to take you to a safe house. You have two options. You call an Uber or you drive yourself using Google Maps. If you order that Uber, that driver arrives at the bank to you running toward the car with a big bag of cash, then proceeds to take you to the safe house. That driver's probably going to be charged with a conspiracy crime, such as aiding and abetting. So conspiracy crimes are when you knowingly assist in furtherance of a crime. And that makes sense, right? We don't want people to help criminals. Peter rehashes how conspiracy crimes work here.
That's you have to prove agreement, and you have to prove some overt act to further the conspiracy. You didn't do the crime, but you agreed with someone that the crime should be done, and then you did an overt act to further the crime. And so that's what you have to prove in conspiracy versus a primary offense where you actually do the crime, right?
Okay, now what if you drive your getaway car yourself using Google Maps? You're standing outside the bank, the alarms are blaring, and police sirens are approaching in the distance. I don't know if you've seen Reservoir Dogs, but picture that scene. When you type your safe house location into the address bar in the Google Maps app and drive there, Google isn't liable. Google shouldn't be liable, and neither should the developers who wrote the underlying code. That principle is obvious. But that principle is important to understand because courts in the US and the Netherlands, some at least, have basically decided that Google Map developers are liable for crimes that happen using their tools. Now, obviously, there's some distinction, but if you swap people use it to drive places with people use it to send things places, suddenly those developers are being arrested, jailed, and found guilty in a court of law. Peter van Valkenburgh actually thinks the analogy of Google and Uber isn't strong enough, meaning the case is stronger for software developers than that Google Maps example. I'll let Peter explain.
I even think that the Google Maps analogy is not strong enough, because Google is a big for-profit corporation with a lot of closed source software, a lot of systems that they fully control. Interesting question. If somebody was leading a high-speed chase, and Google had a lot of information about that driver and where they're headed and all that, what are their obligations, right? And could they be held liable for failing to help the police during that high-speed chase, given that they might have a GPS lock on that guy's car and all kinds of other things?
And so what the U.S. Department of Justice has essentially argued is that Google Maps should have a ride-sharing license because people use it to drive places. Only in this case, the equivalent of a ride-sharing license is a money transmission license. You might be wondering, what is a money transmission license? Well, let's go back to the history. This is basically a government-issued permission slip to operate a business that moves money on behalf of other people. The concept emerged in the era of physical transfer, when businesses would transport money locally or across state and international borders, and a lot of things went wrong in those early periods, which is why these rules emerged. I want to talk about the two main parts of that story. Both, like in this case, involve advances in technology: the steamship and the telegraph. From 1890 to 1919, more than 18 million immigrants arrived in the US. Those immigrants needed a method to send funds to relatives back home. Enter steamships. And this is from the Conference of State Bank Supervisors. They said, quote, known as immigrant banks, steamship operators and their staff would take funds from immigrant populations back to Europe and Asia. While some states considered immigrant banks to be engaged in illegal deposit taking, others created a framework for protecting consumers from malfeasance. One of those frameworks was in New Jersey, whose law most resembled today's money transmission rules. Compliance was a bit cheaper back then at a fee of just $10, but that framework evolved to modern money transmission laws. It was also influenced by the telegraph, popularized in the mid to late 1800s by Samuel Morse, yes, the Morse code guy. Telegraphs enabled near instantaneous long-distance communication by transmitting coded signals over wires. Western Union, who many people know as a money transmitter now, built the first transcontinental telegraph line in 1861 and quickly became one of the world's most valuable companies. They realized that you could use this telegraph to transfer money as well as information. So they invented the concept of agents at that point. Here's how it worked. Since it owned the telegraph lines which ran along the railroad tracks, they used the station masters to perform money transfer services. These station masters, these individuals, were independent business persons with cash locked boxes who could conduct transactions and settle with the bank, with Wells Fargo, afterward. Now, Western Union wasn't the only money transmitter. American Express was founded in 1850 by Henry Wells and William G. Fargo, yes, of Wells and Fargo, and became a key player in this money transfer industry. As for those rules, those came in the early 20th century. As I said, in 1907, the New Jersey law was effectuated to regulate the business of money transmission in that state. 48 states followed suit over the subsequent years, and money transmission continues to be regulated and licensed at the state level today. Federal government only got involved when Congress passed the Bank Secrecy Act in 1970, which had its constitutionality challenged at the time and was upheld, though has changed significantly since and maybe could be revisited. At the time, Congress wanted to stop criminals from using the banking system to hide the proceeds of crime. Prior to the Bank Secrecy Act, or the BSA, banks had no legal obligation to keep records of transactions or report suspicious activity to the government. The BSA has expanded over time and essentially has made banks an extension of law enforcement. Now, it's the BSA combined with related rules that allow the federal government to regulate money transmission while maintaining that state licensing framework. But by the early 1990s, anti-money laundering laws were being circumvented. So to address this, Congress went back and they created a criminal statute via the Annunzio-Wiley Money Laundering Act of 1992. This made it a federal crime to conduct a money transmitting business without the requisite state license. So it's a state requirement that you're punished federally for not complying with. The crime was punishable by misdemeanor or felony in the state. So now this is the federal government enforcing state obligations, essentially. It wasn't the first time. This approach was modeled after the prohibition on illegal gambling businesses, which made it a federal crime to operate a gambling business in violation of state law. Criminal statute for unlicensed money transmission, and this is something you may have heard of, maybe you're hearing this for the first time, but you'll hear it a lot as you're listening to this, is Section 1960. Again, this is the criminal statute and one of the most powerful laws in the US, Section 1960. Here it is as written in May of 2026. Section 1960A says, whoever knowingly conducts, controls, manages, supervises, directs, or owns all or part of an unlicensed money transmitting business shall be fined in accordance with this title or imprisoned not more than 5 years or both. Now, there's two parts to it. There's Section 1960A and Section 1960B. Section 1960B is an explainer. It says, as used in this section, the term unlicensed money transmitting business means a money transmitting business which affects interstate or foreign commerce in any manner or degree. And then they have a couple requirements here that basically one is operated without an appropriate money transmitting license in a state where such operation is punishable, whether or not the defendant knew that the operation was required to be licensed. B, fails to comply with the money transmission registration requirements under the civil requirement. Or C, involves the transportation or transmission of funds that are known to the defendant to have derived from a criminal offense or are intended to be used to promote or support unlawful activity. So that's a lot. But basically, there's Section 1960. There's A, which is basically what you'd be charged with, or you should be. I think really a lot of people have made a lot of mistakes here, but I think you should be charged with 1960A. B is more of an explainer to how they can bring those charges on A. Now, Section 1960 didn't look like that when it was first published. I'll let Amanda Tuminelli explain the history here and how the Patriot Act actually changed Section 1960.
I think it's important to remember how we got here. When Section 1960 was created in the 90s, it didn't have B1C. There was only Section 1960 B1A and B1B. It was meant to be the enforcement mechanism for the BSA licensing and registration requirements for money transmitting businesses. So when it first was enacted, Congress's intent was not to create a money laundering light regime, right? Congress's intent was to create an enforcement regime for people who failed to register under the BSA or get the license they needed by their states. Then the Patriot Act happened. And like what often happens is some really terrible event occurs, and then we create laws trying to account for that really bad event. So the Patriot Act added 1960 B1C, and this is in the legislative history, but not as clearly as I'm about to say it. What they were really trying to go after was hawalas and racketeering, like mafia cases. They were trying to go after people who are running like a fake Western Union, but people who are undoubtedly money transmitters. It's just that they would not have been thought of as people who would get a license, right? Like if I'm running an illegal hawala, I'm not going to go to my state and ask for a money transmission license. So they were trying to create some mechanism for going after money transmitting businesses that would never have gotten a license anyway because they're illegal, because they're transmitting criminal funds. So that was the intention with the Patriot Act. Obviously, they could not have conceived of instantaneous digital asset transfer that's non-custodial by third parties, right? So I don't think B1C was ever meant to reach software developers, and it's only in recent years that this creative interpretation was created by the DOJ.
Okay, so now you've got some background. It's important to note that 2 years after Section 1960 criminalized unlicensed money transmission, the Money Laundering Suppression Act of 1994 added civil requirement for registration and amended Section 1960 to make failure to register a federal felony. Section 5330 requires anyone who owns or controls a money transmitting business to register with the Treasury Department within 180 days of starting the business. The important thing to note, though, is the criminal statute. Obviously, that's more important. That implicates people's liberties, and that is Section 1960. As I said, I'm going to get sick of saying, and you're probably going to get sick of hearing, but it's really important that you know that. Obviously, Section 1960 is more important, not only because of potential prison time, but also because, quote, unlike most BSA violations, Section 1960 does not require proof that the defendant knew of the regulatory requirement, proof that the defendant knew his or her conduct was illegal, or even proof that the defendant acted with intent to specifically evade the regulatory requirement. And that was Courtney J. Lynn of the United States Attorney's Office, Eastern District of California, explaining this back, I believe, in around 2007. So there's a good explainer there. 2008, January. But her commentary is a little bit misleading, right? Because while money transmitters don't need to know about the regulatory requirement, they do need to knowingly effectuate transfer of the funds. The statute literally includes the word knowingly. Remember, Section 1968. Whoever knowingly conducts, controls, manages, supervises, etc., all or part of an unlicensed money transmitting business. So knowingly is doing a lot of heavy work in that statute. So while it's true that the USA Patriot Act amended Section 1960 to remove the requirement that defendants knew a license was needed, defendants must still knowingly transmit the funds. That's not my opinion. That's the law. That's what's written in the statute. So this is a lot. And I appreciate you sticking with me on this because it's important. And I hope that it's been pretty easy to follow so far. The key thing to remember is that sections 1960 and 5330 govern money transmitters in the US, with section 1960 criminalizing the offense of operating without a state license. Okay, let's take a breath here. Here's how it works in practice. Once you're licensed in a state, you register at the federal level with FinCEN, which stands for the Financial Crimes Enforcement Network. FinCEN is part of the U.S. Treasury Department and responsible for administering the BSA, that Bank Secrecy Act. Companies that custody virtual assets, so if you're in crypto, you might know the companies Coinbase, Crypto.com, Kraken. Those companies are licensed in the states as well as registered federally because FinCEN has defined money transmitters to include, among others, quote, an administrator or exchange that accepts and transmits a convertible virtual currency or buys or sells convertible virtual currency for any reason under FinCEN's regulations, unless a limitation or exemption applies. So basically, if you're accepting and transmitting, so you're the middleman for virtual currency, and this is how they brought early crypto companies under their umbrella, then you're going to have to register at the state level if you want to offer your product there, and you're going to have to register with FinCEN. That guidance was back in 2013 when virtual currencies were in their infancy, and the government wanted to inform people on what they should know. And remember, that is not the current administration. So regardless of how you feel about the political aisle, this was 2013. This was a long time ago. What's important, though, is that virtual currencies are captured so long as you accept value from one person and transmit it to another. The middlemen are captured. And they list 4 criteria that you can use to determine whether or not you're a money transmitter in virtual currency. Who owns the value, where the value is stored, whether the owner interacts directly with the payment system where the virtual currency runs, and whether the person acting as intermediary has total independent control over the value. Again, total independent control over the value. That's really important to remember throughout. This is guidance from the federal regulator that administers the money transmission rules at the federal level. So what if you're writing software that lets other people accept and transmit value on their own? What if you're not the middleman? Well, FinCEN had guidance on that too. Back in 2019, FinCEN's guidance says you're not a money transmitter. I repeat, FinCEN's guidance says you are not a money transmitter. They even actually wrote specifically about anonymizing software providers back in 2019. Here's that guidance, quote, an anonymizing software provider is not a money transmitter. FinCEN regulations exempt from the definition of money transmitter those persons providing the delivery, communication, or network access services used by a money transmitter to support money transmission services. This is because suppliers of tools, communications, hardware, or software that may be utilized in money transmission, like anonymizing software, are engaged in trade and not money transmission. Isn't that unbelievable? So what they're saying here, and this is so important, they're saying if you create a software that anonymizes people's transactions and you do not take control over those assets, but someone else uses it to make their transactions, you who've created this software are not a money transmitter. That's because these are tools that are used in money transmission, much like internet service providers create tools that are used in the furtherance of money transmission. That doesn't mean they're money transmitters themselves. And to me, I think it's saying that it's fine to build the Tornado Cash software. And I'll let Amanda Tuminelli explain why, when taken as a whole, the 2019 FinCEN guidance essentially says exactly that.
I think if you take the whole of the 2019 guidance, then I agree with you, then that all of the 2019 guidance put together is saying it is fine to build the Tornado Cash protocol. Because to your point, they actually distinguish anonymizing software providers from anonymizing service providers, from CVC wallet providers, from all these different parts of the ecosystem. And what they do in this guidance is say that one of the factors in distinguishing an intermediary from somebody who is not an intermediary is total independent control over customer assets. So that says if you're a non-custodial software developer, you are not going to be regulated as an intermediary under FinCEN guidance. And then in the section which has the exception for service providers, that makes it even clearer that service providers who are not doing the money transmission and are merely providing some service associated with money transmission, those are not treated like money transmitters either. So I think FinCEN was very careful to distinguish intermediaries from people who don't have custody over funds and people who just provide service to some other type of entity or organization.
So this all sounds great, right? Like, okay, we've got some clear rules from regulators on where the line is. You can't be that middleman, right? So where's the problem? Well, developers were rugged by the US government, literally. Now, for those of you who don't know what rugged means, for my wife, who might never listen to this, but hopefully, she does. If you are listening, hello, honey. Rugged means tricked or misled, but worse, where someone says something and then they almost go the opposite way. And that's what happened with these developers. So in August of 2022, the part of the Treasury Department that administers sanctions, the Office of Foreign Asset Control, OFAC is the acronym that we'll use throughout, sanctioned the smart contracts that Tornado Cash was using. And I'm going to explain to you what Tornado Cash is and how those smart contracts work in a minute, but just stick with me here. So these sanctions, and what sanctions do is they just prohibit Americans or the individuals in their jurisdiction from doing business with listed individuals, entities, and countries. Violating an OFAC sanction is a federal crime punishable by up to 20 years in prison and an expensive fine. So you don't want to do that, and you don't want to be caught violating sanctions. But let's look again at that list of sanctionable things: individuals, entities, and countries. The Tornado Cash smart contracts are not individuals, they're not entities, and they're not countries. As you might know, and as I'll explain, those smart contracts are just code running on the Ethereum blockchain, but OFAC still sanctioned them, prohibiting US persons from interacting with those addresses. They also sanctioned the Tornado Cash developers personally, which we'll talk about in a bit. The obvious question that a lot of people would ask at this point is, can OFAC even do that? If they have a list of things that they're able to sanction, can they just arbitrarily add to that list? Can they expand their jurisdiction here? Wouldn't that be outside their powers? It's a smart question. I like the way you think. Well, plenty of others wanted to find out that answer too. 6 Tornado Cash users sued the then U.S. Treasury Secretary, Janet Yellen, and the U.S. Treasury Department. An advocacy org, Coin Center, which Peter is the executive director of, also sued, filing a complaint against the same parties. Coin Center's argument had 2 core components. First, OFAC's regulations only allow it to sanction persons, meaning individuals or entities. Until the Tornado Cash sanction, OFAC had never sanctioned a technology. Imagine them sanctioning Microsoft Word because criminals used Microsoft Word to type up messages and propaganda. That's unilaterally expanding power without authorization. The second argument that Coin Center made was that the First Amendment protects the right to associate privately, and Tornado Cash was used by Coin Center donors who wanted to contribute privately. Okay, so now it's time for a quick 2-minute refresher on how Tornado Cash works. So normally every transaction on Ethereum is public. You can go to an Ethereum scanning software and you can see all the transactions with the wallets. If I send funds to your wallet, everyone can see that transaction. I have some privacy if people don't know which wallet is owned by me, but there are ways to figure that out. What Tornado Cash did or does was obscure that connection by breaking the on-chain link between where money came from and where it went. It's a privacy tool built as a set of smart contracts, so think code that's deployed on the blockchain, on Ethereum blockchain, that executes automatically when certain conditions are met. No human operator is involved once Tornado Cash's smart contracts are deployed. This is the flow. So a user would deposit a fixed amount, say 1 Ethereum token or ETH, into a Tornado Cash pool. When you deposit, the protocol generates 2 random values, a nullifier and a secret. The nullifier is what makes the note good for exactly 1 withdrawal. So you can't pull out more than you put in. That nullifies your ability to do that. The secret is just a randomly generated number that makes it highly unlikely for computers to brute force find, by guessing every possible combination, your withdrawal slip. So together, those get hashed. They scrambled into a mix of numbers into a commitment, which is basically like a sealed envelope that is stored in the pool's smart contract as proof that your deposit, that 1 ETH, happened. So again, you've gone on, you've put your 1 ETH in, you get these 2 things back that are in a hash commitment. Now that your token is in this sealed envelope, that sealed envelope also includes deposits from anyone else who's using the Tornado Cash protocol. The idea is that if a lot of people are depositing and withdrawing into the same pool, an outside observer can't tell which deposit funded which withdrawal, because you can put it in with one wallet address and then you can pull it out into a new wallet address that breaks the link between the two that would have otherwise existed had you just send it from wallet A to wallet B. Now you're introducing a middleman, but this isn't really a middleman. This is really just an infrastructure tool that you're introducing in the middle there. You're basically introducing like an envelope. It's not really even a middleman. It's just some pool that you're using, much like you need the internet to effectuate these transactions. Now, when you want to withdraw from Tornado Cash, you submit the nullifier and the secret via a zero knowledge proof, which basically means you confirm something without revealing the actual answer. The zero knowledge proof does two things. First, it proves you know the nullifier and the secret behind one of those commitments in the pool without revealing which one. So it basically, you give in your slip, they say, okay, great. We confirm that this is the correct slip, and then it publishes the hash of the nullifier so that the contract can mark that deposit as spent. So basically, you're giving them the token, they're publishing that token and saying, hey, this token has already been claimed. So that way you can't come back later and try to claim it again and again and again. Those funds are then withdrawn to a wallet or an address of your choosing with no connection if you want, or back to the same wallet since they came from the Tornado Cash pool. Got it? See, even us non-developers can understand this stuff if you dig into this a little bit. Okay, let's go back to the case where Coin Center sued Treasury now that you understand how Tornado Cash works. That case continued until 2023 when the court ruled against Coin Center on each point. The court found that ownership or legal control are not required for sanctions to apply under the International Emergency Economic Powers Act, which has the acronym IEPA. That's the law that gives the president the power to sanction property. The president delegates that authority to the Treasury Department, which in turn delegates it to OFAC. OFAC maintains a repository of all sanctioned entities called the SDN list. That list is public and searchable. This is how the court justified that claim. They said that the Tornado Cash founders, developers, and members held the governance tokens for Tornado Cash, and that those tokens increased in value as more people used the protocol. Therefore, foreign token holders had an indirect financial interest in the increased use of the smart contract. But that kind of misses the point, right? They're not sanctioning those governance token holders. They're sanctioning the smart contracts. The court also said that those foreign token holders had an indirect interest in the immutable smart contracts, again, that they could not control or change. Seems like a bit of a stretch, and we'll see how courts decided differently elsewhere. The court in this case also deferred heavily to OFAC's national security rationale, basically saying that, hey, if this entity thinks this thing is dangerous enough to be worth sanctioning, we trust them, we defer to them, and we're going to let them do that. And between us, they're almost saying we're going to let them do that even if it infringes on the rights of people and goes beyond the powers that Congress, which is the voice of people, didn't give OFAC. They were also dismissive of any First Amendment and free speech arguments. So enforcement actions actually began right around this time. Now, a few months before the decision in the Coin Center case, in October of 2023, the Department of Justice charged Roman Storm and Roman Semenov, two developers of Tornado Cash, for conspiracy to commit money laundering, conspiracy to violate sanctions, and conspiracy to operate an unlicensed money transmitting business under Section 1960. Yes, developers of non-custodial software were criminally charged for writing and publishing software that others used to move money. As mentioned, these were conspiracy charges, which means that the developers didn't personally launder money or violate sanctions, but that they agreed with others to commit the underlying offense, and at least one person took some sort of overt act in furtherance of that agreement. So you'd think they'd have some proof that someone like Roman Storm communicated with these money launderers, right? Here's his lawyer, Brian Klein, who explains one of the biggest misconceptions of that case.
I think it's important that people understand that Roman never communicated with any of these bad actors. He never had any communications with North Koreans, hackers, or anybody. There's not any evidence ever been submitted at trial or anywhere that he did, and there isn't any. And so I think your touchstone here, or anybody's touchstone, should be like, okay, you would expect that if someone had done that, they might be in trouble, right? Like, okay, if they're actively talking to North Koreans and saying, how can I help you? If they're actively talking to a hacker, how can I help you? Or I built this for you, come use my service. That's a different case. That's not this case. There literally is no communications where the people who misused Tornado Cash, and it was a relatively small percentage, are communicating with Roman or the other founders of the company he built that developed this. Those don't exist. And I think people need to start that as a baseline understanding. Those don't exist.
Now, two Tornado Cash developers, Roman Storm and Semenov, were not the only developers charged at this time. In April of 2024, the DOJ is the Department of Justice, also indicted Kian Rodriguez and William Hill, the developers of Samourai Wallet, on the same theory that writing and publishing non-custodial, privacy-preserving crypto software is money transmission requiring federal registration. But wait, didn't an arm of the US government literally say that privacy-preserving non-custodial software wasn't money transmission? Yeah, they did. That doesn't seem right. Well, let's talk about what happened since. So there is some good news. As I mentioned, CoinCenter wasn't the only party to file a complaint after OFAC sanctioned the Tornado Cash smart contract addresses. There were also the 6 users of Tornado Cash that sued the Department of Justice, users who wanted financial privacy to donate to help refugees in Ukraine, to support nonprofits, etc. This is the Van Loon case. The Van Loon party made similar arguments to CoinCenter, most importantly that the Tornado Cash smart contract is not property under IEPA, that rule that gives the president the authority and that he delegates to sanction property. Therefore, if it's not property, it's not sanctionable. Van Loon also lost in district court, but their appeal was heard and ruled on prior to CoinCenter's appeal in the Fifth Circuit in Texas. And the Van Loon party won. The appellate court agreed that IEPA, which was enacted in 1977, was not written to cover software that nobody owns or controls. And the court noted that Congress enacted IEPA over 40 years before the U.S. government brought these cases against software developers. Here's exactly what they said. This is the Fifth Circuit Court. Quote, perhaps Congress will update IEPA enacted during the Carter administration to target modern technologies like crypto mixing software. Until then, we hold that Tornado Cash's immutable smart contracts, bracket, the lines of privacy-enabling software code, close bracket, are not the, quote, property, unquote, of a foreign national entity, meaning 1, they cannot be blocked under IEPA, and 2, OFAC overstepped its congressionally defined authority. And that last part's really important, right? Congressionally defined authority. We're going to talk a lot about that today. Now, in making this decision, the Fifth Circuit reasoned that because IEPA doesn't define property and because OFAC's definition should be afforded no heightened deference, the court should apply its own definition. And the court said, well, property has a plain meaning. It is capable of being owned, right? Including the right to exclude others. So there's physical property, which is something like your house, like your car. There's also intangible property. Some intangible property can be owned and excluded, like patents or copyrights. Then there's things like ideas, which are not sanctionable. And I think this immutable smart contracts fall closer to the ideas than they do in patent and copyrights. And the court agreed in 2 important ways. And they said, quote, first, Tornado Cash doesn't profit from the immutable smart contracts at issue in this appeal. Some relayers and Torn token holders may receive fees from using the mutable, so the changeable, relayer registry smart contracts, but not from the immutable pool smart contracts, so the pool of smart contracts that Tornado Cash published and can't change. Second, patent and copyrights are ownable, just like everything else in OFAC's regulatory definition. Though they are intangible, someone owns the right to the protections and benefits offered by patents and copyrights. The same cannot be said for these smart contracts. Now, Treasury had also argued that OFAC's definition of sanctionable assets includes any other property, and that catch-all should include smart contracts. Well, the court made a really smart point here. Quote, as a last resort, the department emphasizes the final catch-all for any other property, but the catch-all is not as expansive as the department suggests. It still requires that any property actually be, well, property. Adding an any before a word doesn't change that word's meaning. So TLDR, Tornado Cash's immutable smart contracts were not property and could not be sanctioned. I love those judges for taking the time to understand the facts here and really getting this right, in my opinion. But not everyone appreciated the decision as much as I did. After the Van Loon case, Treasury tried to narrow the judgment to cover only the immutable smart contracts. And on March 18th, 2025, they argued that vacating the entire sanction designation on these smart contracts would undermine national security. And as anyone knows, national security is a very important thing and something to be taken very seriously. However, there are rules that are followed in the United States, and that's what makes the country so great. That's what people who fight for the country are fighting for. They're fighting for the rules. That's what makes the country unique from other countries. So these are important things to be upholding. Anyways, 3 days after Treasury made that argument, on March 21st, 2025, they announced that they were choosing to lift the sanctions against Tornado Cash. Now, listen to Treasury's strategic wording here. Quote, "We have exercised our discretion to move the economic sanctions against Tornado Cash as reflected in Treasury's Monday filing in the Van Loon versus Department of the Treasury case." Unquote. So it seems like they're trying to say, well, we chose to. We didn't do it because we had to. Not ideal to see that they want to sanction things that are property. And like I said, that matters because ideas are not property either. Still, this was a big win for the rule of law and freedoms. Unfortunately for the developers, they were much less successful than the Van Loon party. They all lost in different ways. Roman Sterlingov was arrested after arriving in California. He was convicted of running Bitcoin Fog, a crypto mixer, and is now serving a 12.5-year sentence. It's an important case, and for more details, I spoke to his lawyers about it on episode 135 of Law of Code. Then there's also the two Romans that were involved in Tornado Cash. Roman Semenov is still wanted by the FBI for conspiracy charges related to Section 1960. And then the third Roman, Roman Storm, a developer of Tornado Cash, was convicted of conspiring to operate an unlicensed money transmitting business under Section 1960A. Though most of the reporting on this is wrong, most media outlets, even big law firms, have reported that Storm was charged under Section 1960B1C based on the letter from prosecutors in the case, which retained the charges under B1C, but got rid of the charges under B1A and B1B. And remember, these are like the definitions that explain the charge of 1960A. I'll get to why that's important in a second, but first a word from Roman Storm's lawyer, Brian Klein, on what life is like for Roman since the conviction, because this isn't just a law school hypothetical.
I think Roman is doing as well as one could hope under the difficult situation. This is an incredibly stressful, anxiety-inducing, difficult thing to be going through for anybody who's charged with serious federal crimes, who's facing the full weight of the federal government coming after you. Even if you know, as Roman does, that you're innocent and you shouldn't have been charged, it's still a very stressful, trying situation. He, and this is public, so I can say this, he has, a young family, child he has to, he has. And so there's just a lot of layers to this that make this difficult, both personally and professionally for anybody. And I think he's handling it with a ton of grace, and he's handled it very level-headedly, maturely, which speaks well to him. And he's also displayed a lot of moral courage in this case in defending himself and how he comports himself. I couldn't be prouder to represent him.
Let's read 1960 again. Remember, A says whoever knowingly conducts, controls, manages, supervises, directs, or owns, basically whoever does any of this stuff involving a money transmitting business shall be fined according with this title or imprisoned not more than 5 years. B says, as used in this section, the term unlicensed money transmitting business means, and then it lists A, B, and C, the three things that make up what a money transmitting business has to do to fall within this 1960A. You have to charge them for A because that's where you get the 5 year. There's no rule in C that allows you to do that. Anyway, so yes, he was charged for B1C, but the jury was hung on the other two charges against Roman. Reminder, that was the conspiracy to violate sanctions laws under IEPA and conspiracy to commit money laundering. Now, I'll always be honest in this podcast because my goal is fairness and transparency, and I want to help you understand the legal layer of emerging tech. There are some bad facts in that Storm case. One of the strongest points that Treasury has, I can't speak to the truth of them, but this is what they're alleging, is that 96% of Tornado Cash users accessed the service through the user interface, think of a website that was controlled by Tornado Cash, and the developers made 250 changes to that user interface during the charged period while failing to implement any sort of screening or geoblock to block known criminal addresses from accessing the services. Basically, they're saying, hey, these guys could have slowed down the bad actors, but they didn't. Treasury also claims that Storm and others involved had enough Tornado Cash tokens to make any governance decision they wanted, including upgrading the contracts. But bad facts make bad law, and I'm going to explain why a lot of those shouldn't really even be relevant here. But first, I'm going to let Amanda Tuminelli explain the dangers of changing the law to suit the needs of prosecutors who have facts in a case. And these people are human too, so I see where they're coming from. They want to win. They want to convict the people they think are bad guys. But if you start to manipulate the law to fit your goals rather than aligning your goals with the law, it gets into a bit of a slippery slope. I'll let Amanda Tuminelli explain.
Bad facts make bad law, right? That is a saying that we always said for a long time when I was a criminal defense lawyer. And it's true. Like, if you are a prosecutor, you are going to pick a case that you know is going to play well for the jury. And I'm not saying that's the only incentive. I do believe that prosecutors are trying to correct a wrong or trying to avenge victims, right? Or do whatever other positive incentives that there are out there for prosecuting the right cases. But you can't forget that they also are humans who know that ultimately they are going to present this case to 12 people who have never heard any of these facts before. So when you have something like, let's take the Tornado Cash t-shirts, right? The t-shirts that the developers wore to, I forget which conference it was, several years before this case took place. And it has like a washing machine on it with like crypto on one side, or dirty, looking like a poop emoji, and then like clean crypto on the other. I think that that is the kind of thing where as a prosecutor, you're like, this is going to play great in front of the jury, right? Even though like you and I could very easily say as a legal mind, like this doesn't really matter to anything. Like this is not really relevant to making any fact in this case more or less likely, which is the standard for relevance. But it's going to play really well for the jury. And it's going to make the jury think, maybe there was money laundering in this case, because otherwise, why would they wear these t-shirts? Even though it's obviously a joke, it's an irreverent thing that like is very crypto, right? To like do something, to wear a t-shirt like that. So all this to say that I think that there are many different incentives for bringing a case, but certainly one of the incentives for bringing this case was that they knew that they had facts that looked really bad, even if they may not be legally significant to a Section 1960 charge or to a money laundering or sanctions evasion charge. And I think that that's why they charged 3 conspiracies, because they knew that it would be much easier, that the prosecutors knew it would be much easier to prove that there was an agreement between 2 people to do a thing and only one step in furtherance of that thing versus actually proving the underlying charge itself. So when you think about what it takes to put a case together, you kind of have to think about all of that. It's like the optics plus the law plus the facts here. All of it goes together in making a charging decision. And then choosing to continue this case, there's a whole other set of considerations in choosing to rebring the case and try it again.
Now, these facts are very, very important. And that's why we need to get into the reality of what happened here. The court in Van Loon understood what was happening with Tornado Cash. And this paragraph from that decision, that Van Loon decision, is really important to understand. Quote, although some of the Tornado Cash developed smart contracts were immutable from the start, the developers initially retained the ability to update the pool smart contracts codes. So in other words, these pool smart contracts were originally mutable. But in 2020, remember this is 3 years before Roman was charged, the developers announced a trusted setup ceremony in which they would eliminate their control over the pool smart contracts. In that ceremony, more than 1,000 users participated in at least 20 smart contracts, including the pool smart contracts. Remember, the pools where all these funds are going became irreversibly immutable. Consequently, the pool smart contracts became self-executing and could no longer be altered, removed, or controlled. So anything that happens on these smart contracts are outside the control of the people that publish them, much like anyone who builds a highway is not in control of who is on that highway. The problem is Storm's legal battle remains ongoing. And unfortunately, As I mentioned, he was convicted under Section B1C, they're claiming, which, again, it probably should be Section 1968. Here's Brian Klein to explain the latest on Roman's case.
Sure. Right now, there is a motion called a Rule 29 motion pending, which is a motion you file after the jury comes back to dismiss or vacate the verdicts. We had a hearing in early April in front of the judge, where we spent over several hours with the judge, both the prosecutors and the defense, answering her questions about the motion that we filed to dismiss the case, the Rule 29 motion. And that's now under submission. She's taken it under submission. So we expect her to rule in the next month or two, could be sooner. The motion itself was almost 100 pages, plus the government's brief, plus our reply. So there's a lot for her to digest. She's a very hardworking, diligent judge. And so we expect a ruling relatively soon. In the meantime, the government asked to hold a retrial date if she denies our motion in whole or in part. And so the judge has selected, with the parties' input, October 26th of later this year, if there is a retrial is necessary, for the retrial to commence.
And what would happen in the retrial in terms of these charges? Would it just be the two charges where the jury was hung?
It'd be the two charges where there was a deadlock of the jury. So the 1960 charge would not be retried. So it would just be the conspiracy to commit money laundering, the conspiracy to violate sanctions.
And so obviously we're going to keep a close eye on what happens there. And it seems like we could get an update relatively soon. The Samourai wallet founders fared much, much worse. And I'm not sure if you're familiar with Samourai wallet, but if not, it was a privacy preserving tool, much like Tornado Cash was, only this was tailored towards Bitcoin. It was a self-custodial, meaning you would have your own custody of your assets, much like you'd be the driver in the Google Apps versus Uber example, that had a privacy feature called Whirlpool. And Whirlpool coordinated batches of Bitcoin to combine multiple transactions that would obfuscate or hide where your assets moved. It had another feature that allowed you to add intermediate steps between a sender and a final recipient. So much like the Tornado Cash, it's you put funds into a pool, it gets mixed up with a bunch of other funds, you can pull it out anywhere else. Only in this case, you could add an extra step here. More than 80,000 Bitcoin passed through Samourai wallet. And the founders never controlled any of those funds, any of those assets. That was all on the smart contracts. And now the facts were bad here. The DOJ said that in one WhatsApp exchange, when asked to explain the concept of mixing, one of the founders described the process as money laundering for Bitcoin. The other founder made similar comments, and both pled guilty to conspiracy to operate a money transmitting business, which carries a sentence of a maximum of 5 years in prison under Section 1960A. They also forfeited the $6.3 million in fees that Samourai had earned. One thing stands out to me in the Samourai case, the Roman Storm case. The prosecution really hated the facts. They're human after all, and they want to win cases they start. They were intent on seeing justice to the people who they believed were doing something bad by creating these tools for criminals. There's evidence that prosecution really, really wanted convictions here. And so the defense counsel in the Samourai case actually filed a Brady letter disclosing that 6 months before the Samourai indictment, those same prosecutors in the Samourai case asked FinCEN, their colleagues in the federal government who are responsible for money transmission, whether Samourai's non-custodial wallet and CoinJoin software constituted money transmission. And FinCEN's reply was no. No, it's not money transmission. But these prosecutors in the Southern District of New York went anyways. So you've got the entity they would register with at the federal level saying, no, they couldn't register with us because they're not a money transmitter. But yet you have the prosecutors still going after them. And so if Samourai had gone to FinCEN and register, they probably would have been told by FinCEN that they weren't a money transmitter and they can't register. Yet prosecutors went after them anyways. I'll let Peter explain a bit more about that Brady letter and why it's so important.
Brady violation, I think, is definitely a line crossing moment to me for the conduct of the prosecution in that case. And we don't have the same smoking gun in the Roman Storm case, but it's just evident that prosecutors are aware of this clear guidance document that happened in 2019, are aware that high-powered law firms were offering opinions based on that for 2019, 2020, 2021, 2022, all the way up until these prosecutions. And in light of these prosecutions, we saw some of those law firms even write, very clear statements that this is just off the rails. Like there's an excellent memo from, I think, Cravath, like not exactly a small, boutique law firm focusing on crypto law. No, like one of the biggest law firms, most famous law firms in the world saying, whoa, this is a rug pull effectively. And I like that framing because if you come out and you say that software developers who don't have control of funds are not money transmitters, and you're the regulator that license money transmitters, it is a rug pull to then have a prosecutor come at you and say, our interpretation of money transmission is different than the regulator you'd get a license from, so we're still going to prosecute you, even though the regulator wouldn't have given you a license because they explicitly said you didn't need one. And so that is very upsetting.
And as is now very obvious, there's significant policy implications with letting prosecutors bend the law. That's not a country and that's not a world we want to live in. Here's Roman Storm's lawyer, again, Brian Klein, to talk about that.
I think you get to an important point, which is prosecutors in general are given a lot of discretion on the charges they bring. And what we all worry about, and we all should be worried about, is when they're a hammer and everybody's a nail. And when there is a win at all costs, and it becomes, they can't step back at each phase and say, is this the right thing to do? Does this, now that I've learned this, does this still comport with, is this still illegal in my mind? Is this still something that's a problem? Or does learning these facts change how I view, rather than how do I take these facts and still pursue my theory, right? How do I figure out a way to work around these facts? And so I think that's a broad concern we should all have with the tremendous power that prosecutors are given. And we all want and should hope, and they should use their discretion well, but also err on the side of not bringing cases and err on the side of, if you have a question, if there's a doubt, if things happen, being able to revisit that, rethink that, and frankly, have the courage to change your opinion. So I think that issue is broader than any one case, and it's something we should all be mindful of.
It's definitely something we all need to be mindful of. And these cases are why it's so important that users of these tools, not just the founders or the people being indicted, push back. When users who just want private transactions fight back, like in the Van Loon case, the facts are so much stronger and you don't have opposing counsel super motivated. And you can support these type of advocates through organizations like Coin Center, the DeFi Education Fund, and help Roman Storm via freeromanstorm.com. Roman Sterlingov's defense fund is freeroman.org. It's also important to remember that the Department of Justice can choose to drop these cases at any time, recognizing that, hey, now we better understand the law and the facts of this case. And hey, maybe these money transmission charges we thought were applicable no longer are. It takes courage to do that. And courage and a fear of prosecution is exactly why Coin Center fellow Michael Lewellen sued the U.S. Attorney General to get some answers here. Otherwise, anyone building tools could be a target of law enforcement, as Brian explains here.
I think that's one of the grave concerns here, is that this case, even though it may seem narrowly focused on one person and one type of tool, the precedent the government could use here, these prosecutors could use here, is expansive. And basically what they're saying is, well, trust us. We won't misuse this. We'll only identify the wrong people who do the wrong things. And our system isn't built actually like that. It's built the other way, which was as safeguards and protections and checks and balances, which is why we have courts, which is why we have the legislature.
That principle is why Michael Lewellen went to the court for answers. Now, who is Michael Lewellen? He's a crypto expert who consulted on the development of major smart contracts on Ethereum. He's also friends with Peter, who I'll let explain a bit more about Michael here.
Yep. So Michael Lewellen is a great friend of mine, and it was actually at ETH DevCon for Ethereum in Bangkok, where we were talking, and he was telling me about Pharos, which is this privacy preserving crowdfunding tool he was already working on and wanted to release. And we were talking about the Roman Storm case. And I said, Michael, you should be careful. Like, there are right now multiple ongoing investigations. Some of those were dropped, by the way. Like, it's not just Storm and Samourai. There were others that I can't talk to because a lot of that is, personal knowledge. And
Peter,
and
and I can cut this if you're not allowed to say. Could you give me a sense on how many others there might have been? Like, was it one or two? Was it more than a handful?
I know of 2 high-profile investigations being run out of the Southern District of New York of what I would call blue chip level DeFi protocols, like not even privacy focused, for unlicensed money transmission.
Wow.
And I know also of founders of those protocols who had their homes searched with a warrant, thank God, because you do need a warrant to search a house in this country, at least, often in the middle of the night or very disruptive raids. So, things were very serious then when I was talking with Michael. And I think they still are quite serious, although some of those investigations didn't proceed to enforcement. And I said to Michael, like, look, this is a speech matter. This is something that has to do with your First Amendment rights as an American who just wants to publish software. And in the context of chilled speech, I don't want to publish my new ideas for how to do good things in the world with software. You do have a better chance of getting pre-enforcement judgment about the meaning of the law that's chilling your speech, even if you haven't had an investigation start against you or something like that. And so we got to talking. We brought lawyers on board, and Michael decided, yeah, I would love to actually sue for pre-enforcement judgment as to whether I'm in danger of being prosecuted for unlicensed money transmission if I publish this Pharos privacy-preserving crowdfunding software. And so he brought that case in the Northern District of Texas. He's lived in Fort Worth his whole life, and I think it's the right challenge because, as you said, bad facts can cloud judgment, and whether it's maybe ill-advised tweets or other things that happened in the Samourai context or the Tornado Cash context, I think there's some of that going on. And just the fact that North Korea allegedly used that tool, the Tornado Cash tool, for the amount that they used it in, colors a lot of judgments. And so, yeah, if we really want to just make sure we're focused on what the law means without prejudice of specific facts that could confuse us or lead us down the wrong path or make us make quick judgments, it would be excellent to have something like a pre-enforcement challenge from someone who's just a good guy. Michael, a lot of people in the Ethereum and Bitcoin community have known Michael for like 10 years now. He actually helped us at Coin Center when the Tornado Cash sanctions got announced, because we were both at a conference in Las Vegas. It was a Zcash conference. And I was like, I need to know whether these smart contracts are immutable or not, because I need to know whether or not we can challenge this under grounds that it's outside of IEPA's statutory authority. And he's like, yeah, I work at Open Zeppelin. I analyze smart contract code for a living. I'll tell you if they're immutable. Now, he made me this beautiful spreadsheet with all the different relevant Tornado Cash contracts. And so he's like a good guy who just wants to write good software and doesn't want to end up on the wrong side of the law. He has an earnest desire to know what the law means. And so I think this is a perfect vehicle for somebody personally to get a better sense of their safety as a software developer, because they deserve that better sense. And for the rest of the developer community, hopefully also to learn, because right now we're only learning from this one still live case in the Southern District of New York from Roman Storm. And it's tough. And even if it wasn't tough, we should have multiple cases on this. We should have a circuit split on this. We should get the Supreme Court to ultimately opine on a matter as weighty as, can I publish my open source code without a license? That's fundamentally important to the future of innovation in America and the liberty of so many people that are good people who I care about.
Now, as Peter mentioned, Lewellen wanted to publish a non-custodial crowdfunding system that deploys assurance contracts. And here's how it works in plain English. Essentially, this is a system that allows you to support fundraisers. So say I wanted to support a new novel sort of cancer treatment that was fundraising. I would, if I wanted to do that anonymously, if I didn't want everyone to see, what research I was supporting, I would send it to Llewellyn's smart contract on Ethereum, which would hold the assets until the fundraising goal was met. So say they were raising $1 million to conduct this study. it would sit in a pool until that $1 million was said to be allocated, and then at that point it would be given to them. If that $1 million threshold wasn't hit and they decided, hey, we're not going to go through the project, I would get those funds returned. Now, Lewellen would maintain the front end that you'd use to access this. He'd get a fee when the campaign succeeded, but at no point would he control or possess the assets that were in this contract. It would be mine, it would be sitting in there, and I would be using these rails. And this protocol is called Pharos. Transfers on Pharos would be private by using zero-knowledge proofs, which is, again, that cryptographic technique that allows you to prove a statement to be true without revealing the underlying information. You could prove that you made a contribution and are entitled to a refund without divulging which fundraise you wanted to support. It's a really important idea. And if you think about it from a political standpoint, what if a political party could stop you from donating to the other side, whether you support Democrats, Republicans? The US is a country where any party can fundraise, and that's an important part of what makes the country great. Many populations and many people in the world are not so lucky to live in that type of country because they don't have the same laws of the US. Maybe Pharos can help those people. As Coin Center explained in their accompanying announcement, Lewellen makes 3 claims in his lawsuit. 1, the Department of Justice lacks the authority to bring a prosecution against him for running an unlicensed money transmitting business, as it has done against other software creators like Roman Storm. 2, if they had the authority, even if they had the authority, saying they don't, but if they did, that would violate the First Amendment because you're putting people in prison for publishing and writing code. That's a free speech issue. It would also violate due process. And due process prohibits the federal government from enforcing laws in an arbitrary and vague manner, almost like issuing guidance saying something's okay and then saying, wait a second, no, we said it's okay, but it's actually not okay, and going after people. Then there were a group of amicus briefs that were published from the DeFi Education Fund, Blockchain Association, Coin Center obviously was involved, and nearly every other advocacy org saying that, hey, even if Lewellen wanted to register, even if the government wanted him to register, there's no way for him to. The rules would need to change in order for him to register. So then maybe change the rules. One reason is that the federal registration requirement requires naming the person who owns or controls the business. As the Fifth Circuit held in Loon, if he's just publishing smart contracts and there's not an accompanying business, those are not capable of being owned. And that's an important point, right? Like, because what you could say is, okay, well, those smart contracts are part of the business, sure. But you can't be liable for what those smart contracts are doing because, yes, your business could be doing one thing, but those smart contracts are basically like someone creating a highway. Like, you can't stop someone once those have been created. Anyways, another reason is that the Bank Secrecy Act requires money transmitters to collect customer information, file suspicious activity reports, and implement anti-money laundering safeguards, such as blocking fraudulent transactions. Again, the developer of these immutable smart contracts, like a builder of a highway, doesn't have that type of control here. So we need a solution, and that's why Lewellen turned to the courts. The problem is, in March of 2026, a court in Texas dismissed Lewellen's case. Despite the ongoing prosecutions and current convictions against software developers, remember, one is even wanted by the FBI for this exact thing. The court said that Lewellen fails to show that there is a substantial threat of prosecution under Section 1960. In dismissing the Lewellen case, the court cites a 2025 case from the Fifth Circuit that states, quote, there must be some evidence that a rule would be applied to the plaintiff, unquote, when he brings a challenge like this. Well, yeah. Didn't the 3 Romans and the Samourai guys get convicted or charged with unlicensed money transmission after building privacy-preserving, non-custodial software that third parties use to launder money? Yeah. So why doesn't the court recognize the threat Lewellen faces? It's a good question. Here's what the judge said to try to differentiate Lewellen's case from the Tornado Cash and other cases. Quote, the core conduct in those cases is money laundering. By contrast, the core conduct here would be running a business. And that made me shake my head because I couldn't disagree more. Tornado Cash was a business, much like Pharos is a business. The core conduct of both businesses is a non-custodial, privacy-preserving tool. And as Brian Klein has already told us, there is no evidence of any discussions that Roman had with these money launderers. How could that be the core conduct in that case? Doesn't really make much sense. Let's go back to Peter here to talk more about Lewellen and why there is that credible threat of enforcement.
Lewellen wants to create a very legitimate tool and a business in publishing that tool that is not money laundering. But that's where Roman was before money launderers used his tool. So there is no difference in the course of conduct as described in Lewellen's facts in his call for declarative judgment and Roman's facts if we go back to Tornado Cash when it was first being developed. And so still very credible threat of enforcement, because you can bet if Lewellen's legitimate tool from his legitimate business gets misused by bad people to do bad things, he'll be in the same seat as Roman Storm if they decide to prosecute, which of course they always can.
So baked into the court's reasoning is this assumption that these tools are money transmission, even though, as the DeFi Education Fund has found, there are no prior cases where people built a tool that they can't control, that they don't access, that they're not the middleman, that someone else uses to transfer funds. Yet this is exactly what's happening here. And the court is just completely dismissing that. They also mentioned that DOJ memo, and that is known as the Blanche memo. It's in reference to the acting Attorney General, Todd Blanche, who issued this memo on April 7th, 2025. Titled Ending Regulation by Prosecution. The memo states that the makers of certain tools should not be liable for what potential users do with these tools. Now, that's very important. It's great news for anyone who creates software. So thank you, Mr. Blanche. The problem is there's limits to this. It's a memo, obviously not law. It's also not comprehensive. And the DeFi Education Fund has an excellent explainer on that latter point. As they note in that explainer, the Blanche memo is about Section 1960 B1A and B, not C. Remember, B1A and B were what the government said we're no longer charging Roman Storm for, but they kept the C charge. And reminder, in that statute, the C charge is the one that says you are otherwise involved in the transportation or transmission of funds that are known to the defendant to have been derived from a criminal activity or intended to be used to promote or support unlawful activity. So in the Lewellen case, remember that the court dismissing Lewellen said, well, no, there's no credible threat to him partly because of this memo. And I'll let Peter explain why that's the case here.
On the actual standing and ripeness issue, and I actually think it's more of a ripeness issue than a standing issue, and I'll explain why in a second. You know, Michael, when he brought the lawsuit, was genuinely afraid of prosecution, and he was not publishing his software for that reason. It was basically baked. In fact, I've seen demos that he was willing to show me, and so he's like genuinely afraid of prosecution. We see ongoing investigations. We see the two prosecutions, the Samourai wallet prosecution and Roman Storm. And what we get as far as clarity from the administration at that point is effectively nothing. Like, yeah, you might be next. It was radio silence. And that's when this case was brought. This case was originally brought, it was Lewellen v. Garland. It was in the last month of the Biden administration. Now, since then, and the dismissal at the district court level in Texas mentions this, there was a memo from the DOJ. It's referred to as the Blanche memo after Deputy Attorney General Todd Blanche, who is now going to be the acting AG, actually.
Yeah.
Which is interesting. So this appeal might end up being named Lewellen v. Blanche, which is funny because a factual issue on the standing part is this Blanche memo. And the Blanche memo says we are deprioritizing enforcement of unlicensed money transmission prosecutions in the context of developers who don't have control over funds. And, you know, I have, as someone who runs CoinCenter, I'm happy for that statement. I like that statement's out in the world. I don't want them to be prioritizing enforcement against software developers for a crime that they didn't commit, i.e. transmitting money, because they don't actually transmit money. But I'm frustrated for Michael Lewellen because that statement, we're deprioritizing enforcement here, is what the district court seized on when it said, well, you shouldn't be scared. You shouldn't be worried about prosecution. See, the administration, the DOJ is saying they're deprioritizing enforcement. To me, that, and this is me speaking as like a lawyer and a lawyer who's very interested in criminal defense and very interested in the Constitution, that is not something you should take comfort from, that alone. That is not a legally binding interpretation of what the DOJ thinks unlicensed money transmission is and is not. It is not a promise. It is not a non-prosecution agreement with a specific party who could then trust that they won't be prosecuted. It is a statement of enforcement priorities. And that means they can change priorities the next day and there's no foul on them, but surprise on all of us because now you're a priority for enforcement. And in the long run, this is also not going to work because, sure, okay, maybe this DOJ under this presidential administration is deprioritizing, but the next one could very well make it a top priority. And it shouldn't be about whether this is something the DOJ wants to go after or not go after. The whole question is this a crime? Not, will I be prosecuted for this crime? Just, is this a crime? That's what we want to know.
Okay, now let's get back to that memo, that Blanche memo for a second. And I want to zoom in on 4 keywords here. The memo says the Justice Department will stop participating in regulation by prosecution in this space, specifically unwitting violations of regulations. Unwitting violations of regulations. Unwitting. Well, unwitting implies knowledge, and lawyers love to use the Latin term mens rea, which translates to guilty mind. But wait a second, okay? We literally have guidance from FinCEN that says the developers are not money transmitters. So why does a guilty mind even matter? It shouldn't, especially because every prior court case involved a middleman. Yet the Blanche memo further emphasizes this guilty mind. Here's Amanda Tuminelli for a little bit more on that memo.
So I think you're right to say that overall this memo really positive for the crypto ecosystem as a whole, because there's lots of good stuff in there about the DOJ ending regulation by prosecution. All of that's great. So I want to be clear that it's really only on 1960 that I really wish that it had gone farther, honestly, because to your point, what it says is, we're not going to go after pure registration violations of 1960 B1A and B1B. And those don't really ask this mens rea question that you're talking about, right? So this reference to unwitting is sort of saying, we're not going to say anything in this memo about the mens rea requirements for other parts of 1960. And the memo actually even says very specifically in a footnote that it's not commenting on 1960 B1C. I think the Blanche memo is basically saying we're not going to comment on the mens rea part of all of this, and we're only going to tell you that a pure registration violation is something that we're just not going to regulate by prosecution anymore. So I just think it's a very narrow commentary on what had been happening so far.
Again, it shouldn't matter if someone knows about the requirement to register as a money transmitter if you're not actually transmitting money. Right? That's something Peter agrees with, and I'll let him expand on that a little more.
And it goes to, I think, an underlying flaw in the statute itself, in 18 U.S.C. 1960, which is that you have the statute that says this is a statute about unlicensed money transmission. And yet 18 U.S.C. 1960 A1C is not about money transmission. It's about knowingly transporting criminal funds, which sounds much more like a money laundering statute that's squeezed into a money transmission statute. And so read in isolation, and this is exactly what the prosecutors are doing, they're zooming in on this tiny little part of this criminal statute. It seems to say that there's basically a strict and mere knowledge requirement to charge someone with 18 U.S.C. 1960 for transporting criminal funds. And transporting can mean things that aren't typically understood as money transmission, maybe by FinCEN's guidance and things like that. And that's crazy because that little prong is nested within a larger statutory section, which is unlicensed money transmission. So you're absolutely right, Jacob. The first thing that you have to ask yourself is this defendant doing money transmission? Yes or no? And FinCEN says no, the regulator. And any reasonable interpretation of money transmission, I think, is also no, because Roman can't stop the money. He can't touch the money. He can't do anything to the money because the money's never in his hands. It's in software that is on the Ethereum blockchain. And yeah, he published that software a while ago, but he can't take it down. It's immutable. So what is he supposed to do, right? And so, and so the answer is no. And yet you've skipped that preliminary analysis, which is essential, and gone to this sort of strict knowledge scienter requirement for any transportation of criminal funds, loosely defined. That's just not a good faith reading of the statute as a whole.
Now, the Department of Justice memo, the Blanche memo, wasn't the only thing we got from them. They've actually been really helpful in sort of explaining their thinking here. We also got a speech that addressed Section 1960 B1C. Then acting Assistant Attorney General Matthew Galeotti said that the Department of Justice would not approve new Section 1960 charges, quote, where the evidence shows that the software is truly decentralized and solely automates peer-to-peer transactions, and where a third party does not have custody or control over the assets. Wow, that's really good, right? Where the evidence shows software is truly decentralized, automates transactions, and you don't have custody. They won't approve new Section 1960 charges. Really good. Amanda has some good thoughts here. Amanda, and some people push back, and I'll explain why I'd push back on the speech as well, but I want Amanda to share a really positive side of this speech.
The reason why this speech actually did matter and was such a good thing for the industry comes from understanding how cases get put together and how criminal defense works before the indictment happens. You know, often the public really gets clued into a case once the indictment drops and is made public, but there's a lot of soft advocacy that goes into cases before that point. So often, if you have a client who is under investigation or who you have a suspicion may soon be under investigation, there are often many conversations that happen with the DOJ before the indictment. Usually there's a document request. People ask if you want to cooperate or if you want to come in for questions. There's things called proffers where you go speak to the DOJ and tell them what you did or didn't do, right? There's a lot of advocacy that goes into trying to avoid an indictment from happening. So this type of speech that says it is the DOJ's policy not to charge cases where software developers don't take custody or control over funds is important in those conversations, because as a criminal defense lawyer, you're going to say to the line prosecutor in front of you, the DAG said several months ago or a year ago that you aren't pursuing these cases anymore. And it's and taken with the Blanche memo, which says you need permission to charge a case that's inconsistent with the Blanche memo. You shouldn't be pursuing my guy, right? That is a conversation that happens. I know from friends who are criminal defense lawyers that they have cited this speech. I think it just doesn't rise to the level of the public knowing how it's being used, because those conversations are happening behind the scenes on a one-to-one basis. I also think it's a really big deal that the DOJ is out there talking about the difference between custodial and non-custodial software, even making that distinction and distinguishing third-party liability, right? That principle we talked about earlier, distinguishing when a third party does something wrong versus a developer themselves. These are important principles for the DOJ to be acknowledging in public.
Galeotti, like everyone else, skips the question of whether anything is actually being transmitted. Basically saying, hey, if you know that people are using these funds and they use and you help them do that, you'll be in trouble, which makes sense. The problem is that they're putting sort of the cart before the horse. You need to actually be transmitting money, right? Like if you're not transmitting money, it doesn't matter. It's a really important question. Like, why should intent matter if you're not actually breaking a law? Imagine you grew up thinking that it was illegal to wear white after Labor Day. It should be illegal to wear white after Labor Day, but it's not. And you didn't know that though. And intending to violate the law, you wore your favorite furry white sweater in December or your Air Force Ones. It's a bad fashion choice, but it's not illegal. Yes, you had ill intent, but your intent doesn't matter since you're not doing anything illegal. Now, to be clear, I'm not complaining about the speech, and I'm not saying also that any of these developers had intent to assist criminal conduct. As Brian has said, there's no evidence that Roman Storm even communicated with the people that he's convicted of assisting. Now, Galeotti continues in his speech, quote, where a third party does not have custody and control over user assets, new 1960 B1C charges against the third party will not be approved. So if you don't have custody and you don't have control, new charges won't be approved. Though if criminal intent is present, other charges may be appropriate. That's a really important point, right? Like, sure, other charges could be appropriate, but you're not a money transmitter if you don't have custody or control over those assets. And criminal defense lawyers can reference this speech in conversations with prosecutors. So if a hack happens and someone uses your financial rails, this DOJ speech suggests that developers wouldn't be liable for that specific charge. Though, as the then acting assistant attorney general and now head of the criminal division at the DOJ, Matthew Galeotti, has said other charges may apply if intent is present. And intent is such an interesting question here. And that really is the heart of this whole debate. How can someone be held liable for money transmission when they aren't actually transmitting money? I've had to do this entire podcast because it's so ambiguous. Well, thankfully, the US has a rule for resolving ambiguity too. I'll let Peter explain that.
And you also hinted at the interpretive issue there, which is the rule of lenity in our constitutional canon, which says when a statute can be read two ways, like 18 U.S.C. 1960, the unlicensed money statute, you need to read the ambiguity in the favor of the person whose liberty is on the line. And I actually can't remember. I need to go back now and look at her oral rejection of the motion to dismiss, which has been transcribed. I don't think the rule of lenity comes up anywhere in that opinion. And that bothers me a lot, just as a American who believes in our system of ordered liberty and the rule of lenity being actually a critical part of that. So that, you know, when the world is uncertain and you get swept up into a prosecution, you can rely on a judge that's going to say, well, because we don't know what the law means yet here, at least in this case, I'm going to rule in favor of you as the defendant. And that didn't happen in this case. And that's a shame. And also, and I'm going to go a little bit off the rails right now. Hopefully I won't get a call from like our political consultants later. In the current political climate, though, where people on the left and the right, actually, we don't have to make this left or right, are very much concerned about lawfare and the abuse of our legal system to go after people for political gain, to effectively like villainize a potential candidate for something. You really don't want to have an ambiguous criminal code and extremely flexible rules for when prosecutors can drag you into a venue in another state to be effectively unbridled. It will become, and it already in many cases has become, a tool of political warfare. And that is the beginning of the destruction of our otherwise exceedingly important, rational criminal justice system.
That is why it's so important, not only for non-custodial software developers, but for anyone who builds a tool, that Michael Lewellen continue his battle in court, that Roman Storm continue to fight for his freedom. Speeches are not law. Policy memos are not law. They are non-binding. They can be changed at any time, and they do not eliminate the underlying legal risk that people who are building tools will face with these slippery slope principles. The district court's ruling in the Lewellen case, dismissing the case because they said he didn't face a threat of prosecution, creates a bit of a catch-22. Developers cannot challenge the law unless they publish the code. If they publish the code and a third party uses it for illicit activity, based on what we've seen in these other cases, those developers could be charged for unlicensed money transmission. Whether they're actually doing that is one thing, but they can be charged for that. We've seen that. So you can't publish your code without risking felony prosecution, but you can't get a verdict on whether you can publish it until you publish it. You see the catch-22 here? Speaking of catch-22, I remember in grade 8, my teacher gave us that book to read. And I just remember thinking I'm way too young for this, but I still think a lot about that book. It's a very interesting read. Anyways, of course, Llewellyn had to bring this challenge, right? Like, he's got to stick with this because we don't know. There's this catch-22. So after Llewellyn's case was dismissed by the court, he asked to reverse the dismissal and allow the case to proceed so that the courts can finally answer the question we need answered, which is, are non-custodial software developers money transmitters under federal law? And if so, how does that match or align with the definition of transmission? Because what you'd be doing is you'd be broadening the definition of transmission, which can be dangerous if it's done by some prosecutor. Like, that's something that should be done by Congress and by the people who the U.S. citizens voted for to make decisions for them, not from a prosecutor who doesn't like the facts of a particular case. Okay, so that was a lot here. I'm going to let Amanda share some sobering thoughts on the Roman Storm case, specifically on the charges against Roman.
I think that the principle that underlies all three of the charges, because we're obviously so focused on the 1960 charge here, but the principle that underlies the whole indictment is that there was a person who created a tool that other people used to do bad things. So it's really saying that the mere creation of that tool that can be used by third parties to do good or bad things is a crime, is a conspiracy. And that's what it really bothers me about this case. It would be different if there were facts that said that the developers set out with the intention to create a tool that was only for the express purpose of committing a crime, right? But that's not what the facts are in this case.
And here's Brian Klein on the risk of this prosecution.
That's our concern, right? That's what this case is. If you're a developer and you build a neutral tool that has a lot of tremendous benefits for everybody that, people engaged in daily life can benefit from and have legitimate need for, which is true for this crypto mixing or a lot of other tools, like I mentioned, the phone, the car, a hammer. Going after people who are inventors or developers who are advancing society in different ways. This case is a great danger to that. And it's right now the focus, but you can be guaranteed that if they succeed here, the wave of cases like this is coming, and it's coming for all sorts of other people and industries. And that's why we need to stop what's happening here.
If it hasn't been clear yet, this directly affects all Americans. This is a country built on innovation. So many good things were built in America. Yet they have seen their share of open source software developers fall from 25% in 2021, so right before these prosecutions began, to 18% in 2025. And that's driven by a lack of clear, durable rules for software development. Thank the DeFi Education Fund for those numbers. To make it a little bit more tangible, even the most profitable startup in the world from a dollar per employee standpoint offers a telling example. It was started by an American who left the country due to the chilling effect of these approaches. Here's Hyperliquid Policy Center's Jake Chervinsky to explain.
I think that the Hyperliquid Labs founder's story is very similar, unfortunately, to many other developers in the industry. These are two Americans who met when they went to Harvard, had productive careers in the United States, decided that they wanted to build a crypto company, but they decided to build it during the Gary Gensler era, when the Biden administration and many other regulators, in addition to the SEC, were really targeting crypto developers for persecution through a campaign of regulation by enforcement, and then even criminal prosecution, where the government had never before explained that conduct these developers were carrying out could ever be subject to federal criminal law. And the Hyperliquid founders decided that they just didn't want to take on the risk of being subject to regulation or prosecution for totally innocent and productive conduct. So they decided to leave the country, and they built Hyperliquid Labs in Singapore, a jurisdiction that historically has taken the exact opposite approach of the Biden administration and regulators like Gary Gensler, who were really very welcoming of this type of innovation. And so Hyperliquid Labs has been working offshore ever since its founding. In addition, the product is not available for access here in the United States because the laws and regulations are still not updated to allow Americans even to access this type of new technology.
Look, I operate on the principle that people are smart, that people are like you and I. They want the best for themselves and their family. And we need some clarity for people so we don't start reducing the tools that are built in one of the freest countries in the world. So what's our best bet, right? Policy speeches are nice. They're not law. Neither are memos. Both can be changed. But thankfully, even if the cases of Storm or Lewellen continue to stall, we have other ways to protect developers and freedoms, and that's legislation. The laws of America are what make it a special country. I'll let Peter expand on that.
That's why we have a constitution. That's what makes America great. Is there will be very hard questions in drafting statutes and interpreting statutes that will call for rapid emergency answers to stop emerging threats. And we will be tempted quite often to take the easy path and just say, yeah, let's criminalize that because we might save lives. We might stop a really bad person from doing really bad things. But we debase ourselves when we do that, and we start to become the very authoritarian regimes we intend to fight using those broad laws. And the Constitution is there to force us to pause, to make a harder choice. Are we going to forfeit our liberty and our privacy just to get at a handful of transnational criminals or horrible people? And the answer has to be no, because otherwise we've abandoned the America that's worth protecting.
Well said, Peter. So what rules are being drafted? In 2025, Congressman Tom Emmer reintroduced the bipartisan Blockchain Regulatory Certainty Act, the BRCA, with Representative Richie Torres as a co-sponsor. Again, this was bipartisan, so by both sides of the political spectrum. Peter recalls when it was first introduced.
The Blockchain Regulatory Certainty Act was a bill that was first introduced in 2017, believe it or not.
Is it really?
Yeah, before any of these prosecutions, before the FinCEN guidance in 2019, because a really enterprising staffer, Landon Zinda, for a brilliant congressman, Tom Emmer, who's now the majority whip, understood these issues, in part because of some briefings from Coin Center, I'll say, and thought, well, this is an area where we're going to want clear understanding of where the line is between a developer being liable for something like unlicensed money transmission and where they should feel safe to just publish software, right? And so that bill was introduced back then. It was bipartisan back then. It was originally Emmer and Soto. It was reintroduced in last year in the House. It was Emmer and Richie Torres, Democrat from New York, bipartisan again. And it was attached in the House to Clarity in House Financial Services Subcommittee and voted on out of committee and voted on out of the House. It's halfway to being law. Well, maybe a third if you think about the president's signature. And so the Blockchain Regulatory Certainty Act defines this category. You've got it here of blockchain developer and control, and then says a non-controlling blockchain developer will not be treated as a money transmitter and shall not be liable under 18 U.S.C. 1960. And the Senate version is actually even more explicit than the House version.
That 2026 Senate version that Peter references was introduced by a bipartisan pair of senators, Senator Cynthia Lummis and Senator Ron Wyden. It clarifies that digital asset developers and service providers that do not custody consumer funds are not money transmitters. I mean, this is a long podcast that explains why we need that. So I'll let Amanda share where things are at on that.
We're currently, as we sit here today on May 1st, waiting to see if the Senate is going to pass their half or their version of the Clarity bill, which would also include a different version, but very similar version of the BRCA. Senators Lummis and Wyden introduced the bipartisan Senate version of the BRCA, which was then put into Section 604 in the market structure bill on the Senate side. So still bipartisan, still extremely important to the industry, no matter where it is found. DEF and many other organizations have said that the inclusion of the BRCA in market structure is an absolute red line for them because, in our view, there is no threat that is more existential to software developers than incorrect criminal allegations, right? So the BRCA, in my opinion, clarifies existing law or to just like state what we all assumed to be the law, but DOJ misread. I don't think it's an encroachment on law enforcement tools. I don't think that it changes anything about prosecutorial discretion or ability to bring cases. It literally manifests what we already thought the law was, which is that if you don't take control or custody over anybody else's money, you're not transferring funds on their behalf, you're not a money transmitter. So it just makes that clear in black and white.
Now, the Senate version of the BRCA adds that a non-controlling developer or provider shall not be treated as a money transmitting business in either a civil or criminal context. Full stop. It clarifies that, quote, non-controlling blockchain developers are not engaged in money transmitting when they do not have the legal right or the unilateral ability to control, initiate upon demand, or effectuate transactions involving a user's digital assets. And the BRCA isn't the only law that we're seeing tabled here. There's also the Promoting Innovation in Blockchain Development Act. In early 2026, Representatives Scott Fitzgerald, Ben Klein, and Zoe Lofgren introduced this to protect software developers. This would actually amend the criminal code, revising section 1960A to state that it applies to whoever knowingly, and then it adds this part, exercises control over currency, funds, or other value that substitutes for currency. I'll let Amanda explain this a little more.
Separate and different effort, but also very important, is the Promoting Innovation and Blockchain Development Act, or PIBDA, as you said, which is also bipartisan. As of today, it has 8 co-sponsors. It was introduced by Representative Fitzgerald, and this would actually amend 1960. So whereas the BRCA is just saying this is how the term money transmitting should be interpreted, the PIBDA bill would actually change the criminal code. It would actually say 1960 should be revised to clarify the person accused of a 1960 violation has to have control over funds, or, and there's like 2 different formulations of it, or that 1960 must be read as consistent with the BSA's definition of money transmission.
So again, as currently written, Section 1960A says whoever knowingly conducts, controls, manages, supervises, directs, or owns. By adding the term exercises control over, you're not changing the laws. You're not giving developers a free pass. You're clarifying the definition and reconciling it with guidance that the government has already given to these people. I'll let Peter explain more.
Let me put it really clearly. This doesn't change money laundering prosecution 1%, 1 iota at all. This doesn't actually amend any of the money laundering laws. That's 18 U.S.C. 1956. And conspiracy charges related to that, this doesn't affect them. If you think you have the case to prove that somebody was part of a criminal conspiracy to launder money, the BRCA doesn't change your case at all. The BRCA is only about unlicensed money transmission as a charge. And yes, prosecutors have historically brought both charges in some cases. And sometimes that's because it's just straight up obvious that this person is a money transmitter. And sometimes it's because this is effectively a strict liability crime and it's easy to prosecute. It's too easy to prosecute. And so if you have a good case that someone's a money launderer, you're still going to have a good case.
Now, Amanda's perspective is also really important here because she was a former defense attorney. I'll let her add to that.
I think that's what gets lost in this is like people think when you're saying, oh, the 1960 charge shouldn't have been brought, you're saying there's no, and therefore there would have been no other way to go after this activity, even if you really, really believe as a prosecutor that it was wrong. The criminal code has a lot of sections in it. There's a lot of different ways you could go after bad conduct. There are tools that are not the 1960 allegation for prosecutors to use. It's just would take like the least creative prosecutor on earth to say, I have no more tools left if you take away the 1960 charge.
And guess what? It's not just people like me. It's not just people like Peter or Amanda who want these changes. Prosecutors, law enforcement, FBI folks are in favor of this change. They don't want the government spending as much time in courtroom debating these issues when we can just solve them by having some clarity about what the rules even are. I'll let Peter explain what he's hearing in Washington.
As much as there's been some vocal pro-prosecution groups out there talking about this section recently, there are people who I respect on law enforcement more than anyone else, who were former FinCEN acting directors, who were heads of the relevant criminal investigatory wings of the DOJ and the FBI during the period where people were first starting to use cryptocurrency to move money, who agree that the BRCA is a reasonable way to clarify an ambiguous law and that it does not hamstring prosecutors. And so there are plenty of former DOJ, ex-DOJ, and ex-FinCEN folks who are not political, who are not captured by industry, which is something I've heard, which I think is actually quite insidious because some of these people are my friends and I believe they're righteous, who agree that this is a reasonable clarification of an ambiguous criminal statute, not some sort of like ripping away authority from prosecutors, because it's not. And then the last thing I'll say, because I just want to say it, you will create a gap in your ability to prosecute money laundering if you don't pass the BRCA. you will actually worsen the ability of American investigators and prosecutors to go after bad actors, because no one will develop these technologies in the US anymore if they're constantly afraid of being prosecuted, even when they did nothing wrong. And so we will cede our leadership on these tools and these technologies. American companies will not build them, and people will build them in other countries, and they will be used globally, and we will have to have a hell of a time with extradition and law enforcement requests to other nations and other police forces, just trying to track down the people who are actually laundering money. Better that the software and the technology is built here under clear and reasonable rules. Then law enforcement has partners in investigations who will help them find bad actors and ultimately bring them to heel. Like, if you were worried about a gap, an enforcement gap on money laundering, you should be in favor of the BRCA.
Now, these changes aren't the only protections for software developers that are being discussed. This podcast has been hyper-focused on money transmission because it is a huge risk, and it's the biggest example of the slippery slope that we could see here. There are also other protections in the Clarity Act for software developers. Again, that's the market structure legislation that's being tabled. I'll let Amanda explain.
I'll also just flag that there are additional software developer protections in the bill outside of the BRCA that are also very important. For example, Section 601 in the Senate version is the protections for developers from being inappropriately classified under securities laws. There's also Section 207, which protects developers from being inappropriately classified under commodities laws, so under the CEA. So both of those provisions are also very important and correct for separate problems for software developers. So when we see the next draft, we will be looking at all of these sections to make sure that all of these developer protections are in there, because there's so many different ways that developers can get caught up in places that they shouldn't, or it would be unfair to classify them or misapply the law to them.
All right, so this was a long podcast, and we're almost at the end here. I want to talk about what's next. So when speaking about the Clarity Act, Patrick Witt, he's the executive director of the President's Council of Strategic Advisors for Digital Assets, has said that, quote, protecting software developers is one of the most important aspects of this bill. It's a core pillar making the U.S. the crypto capital of the world. Criminalizing code does nothing but drive innovation offshore. And that's such an important point, right? If the U.S. wants to continue to thrive, there needs to be financial innovation in the country. And this is what modern financial innovation looks like. Financial innovation doesn't come often from incumbents. It comes from outside industry that are building things in novel and new ways. And that's what's made America a great country, a powerhouse in the world, by opening doors to innovation. And that's what Patrick Witt, that's what all the guests in this podcast have been speaking about. And there's a way that you can actually make a difference too. I'll let Amanda explain.
People can certainly raise these issues to their members of Congress, to their representatives, and to their senators. There is a lot of time left to do that. Your voice matters. Stand with Crypto exists for a reason. If you don't know who your representative is, you should absolutely go on the Stand with Crypto website and figure out who it is. There's templates there to reach out and say, I care about this. I understand that you can support Storm's defense. You can support Alexei Pertsev's defense because his case is still going on in the Netherlands as well. So you can also have more direct impact if you want to support those two developers. But I would not sleep on making your voice heard for your members of Congress. I think it really matters, especially as we approach a vote.
So all this stuff matters. And I've spent about 50 hours putting this together because it's so important. Thank you for listening. It really meant a lot to me. This is part of my mission to help people understand the legal layer of emerging tech so that we can live in a world with transparent and well understood rules that are applied fairly to all. You can stay updated on the Law of Code podcast by subscribing to my free newsletter. It's once a week, just 5 bullets, just basically lets you know when a new podcast is coming. It's at lawofcode.fm. And I want to just say a quick thank you to Coin Center's Peter van Valkenburgh, the DeFi Education Fund's Amanda Tuminelli, Jennifer Rosenthal Menon for reviewing this paper, and to Peter, Amanda, and Brian Klein for participating in the podcast, to Jake Chervinsky for allowing me to use clips from our upcoming podcast on Perps for this, and to James Farrell for engaging with me on X, and to every other thinker really who spent time talking to me about this, not only for this podcast, but in prior ones. Now, I didn't get paid $1 to produce this. I don't have an assistant. I don't have an intern or any team. I did this all myself. It took me about 50 non-billable hours, and that might be undercounting. I did all the research myself. I connected with people. I coordinated interviews. I recorded, edited, and publicized this podcast, and then made all the clips so that you could see this, so that we could disseminate this important information. I would love to do more work like this. And so if you're interested in supporting that through sponsorships, please send me a DM at Jacob Robinson JD. I would only work with people who I admire, who I would want to have a long-term relationship with. So I am talking to some people now, but if you would like to help me to make this the world's #1 legal podcast, that would really mean a lot. If you could reach out to Jacob Robinson JD on X. And as always, really looking forward to what's next. We're going to be talking about perps, a similar deep dive in a future episode, as well as jurisdiction in the internet age. So how can countries get jurisdiction when people are operating offshore using servers located maybe in one country versus another? We'll talk a little bit about free speech. There's a lot of really exciting things coming up, including the Clarity Act as well, that we'll have a deep dive on. Thank you so much for listening. Again, if you could like, share, subscribe, it really means a lot. It helps me grow this podcast and really it helps other people learn. And that's the ultimate goal here. Thanks for joining me. We'll see you next time.